appearing at in person. This case since last 2 years, very urgency to hear this message. Appearing at in person. So another thing.
But this is marked to me.
Yes, it is an endorsement over here.
Jyoti.
Your Honor, another this I need to give an information application to
Sorry.
an application. You said the advocate has been assigned me by you, my lordship. So he's actually related to me and my family since 30 years. Yes, he was at that time my father was in politics and he was the opposite party. So which after that their relationship was a little bit in conflict and now it's very difficult for me to deal with him and as I'm doing in person. I need to next date only at
Which matter you're talking about? Is it assigned to this bench or some?
Yes.
2024 matter, I can't hear.
Sir, it actually
Unless it is specially assigned by the Honorable Chief Justice, I can't handle.
So it is assigned to you. How it is?
Okay, you give the memo. My regular court master will see. Okay, give the memo, we'll see. If it is assigned, then it will be listed. If it's not assigned, it will not be listed. Okay.
Sir, what happened in this? Can I tell for 2 seconds? Sir, it was first, it was assigned, after you, it was assigned to Justice Ekamapatra bench. Ekamapatra Justice bench. Then he was concerned as the opposite advocate, Sibo Mishra, was his relation. He became concerned. Then I had to mention in front of Honorable Chief Justice. Then he have assigned
to me. Okay. Then give it. Then it will be. Okay.
My lord, CRM number 13 of 26. For cancellation of bail, it is for fresh admission. The accused violates the terms and conditions of this honorable court.
Who had given bail?
My lord?
Who had given? This court has given bail.
Yes, madam.
I don't know whether it will come to me. I don't know. I don't know. You give it if it decides to me. I'll just.
Oh, bless me.
Lordship, item 13, soft copy of TCR is available. May grant permission to collect.
Definitely.
Item 8, Your Lordship, we have sought for instructions from the appellants, Your Lordship. I pray for 15 days time, Your Lordship, to do the hearing.
This will remain the weekly list. It is 94 matter. What instruction? You have the paper, argue.
But Your Lordship, we are not in contact with the appellants at all.
I'll appoint you as an amicus. Forget about your client.
Just
in the capacity of amicus, you argue. See, these are 94 matters. You know, you will not get them. Whether they are surviving or not, we don't know. And if it's entitled to acquittal, it's all right. Otherwise, we'll adjust something to do. If it is very hard case, then let us forget about. Madam, let us start first. If it is necessary, I'll definitely accommodate. Let us start. Let us understand what is the case is about. It is a clear-cut case of acquittal. Why should we wait for it and finish it up? If no, it's not a case of acquittal, then we'll see.
But Your Lordship, if only 15 days.
Let it be there. I only request you, please read and come. I'm not today. I'm not taking it up, but
Obliged.
Let it be there, and you come Thursday. Prepare and let us understand what is the case.
Yes.
Okay. Yes.
The 18 notes or 15 notes.
Which one?
Judgment was reserved.
I'll log it. Yes. Zero. Let us start.
Item 1.
Yes.
Also the custody certificate.
Ask for custody certificate or well-being and variable. Period under.
Just
In the
15
capacity of amicus, you argue. What's the period undergone? Well-being and variable. Here the UTP. No. Date of release, date of admission. Huh? What kind of certificate is this? Date of admission.
Calculated is.
As UTP from 47/9/91 to 4/11/1991. Thereafter again after conviction.
Okay, in that way, okay. And after conviction 22 to 1994.
3/3/1994. That is the date of conviction. You should have calculated.
The total period would be
47.
47 days. Pursuant to the order dated 20th 11 2025, the well-being, nothing is there. Is surviving.
The trace report,
The superintendent of district Jajpur has placed on record a custody certificate dated 22/2025, indicating that the appellant has only undergone 47 days, na?
47.
47 days of custody. The custody certificate is same. Who is appearing? You are appearing.
I beg pardon, my lord. He's in custody since last 13 years. Petitioner. No, mentioning. It was fixed on 4/9/2005 for hearing, but could not.
I am not hearing bail, sir. Go to the bail court. I am not hearing bail. Unless it is specially.
Because he's your old man and also 13 years in custody.
Maybe, but unless it is assigned to me, how can I take up the matter?
Because it is a dedicated bench, that is in.
No. I can't do that. Only for appeal. Just see if it falls in my rosters, there is no problem. You have to go to the court with dealing with.
And also, they are also fixed for the hearing of the bail application also because of he's in 13 years in jail custody now.
Okay. Criminal appeal of which year?
Hello?
Criminal appeal of which year?
1/38 of 2015.
It will not come. He is in custody.
Yes, ma'am.
Give it at this.
Also
I'll verify if it comes in this.
Fixed the receive on 4/9/2005 bail application.
I'll check it up. From the yeah. Yes. Who is appearing, by the way, in the first item? Arvidas. No, none appear. That's the problem. B.V. Mahanti. We'll see. Huh? Let it be there.
20,
Thursday we'll see.
Hmm.
Otherwise, I'll appoint him.
20th November, your lordship directed to whoever it will be.
Ah,
That report has not come. In the meantime, we will be
Ah.
covered.
Thursday. Yes, next. Item 2. Just see the order dated 16/1/2026.
Report has come.
Because, huh? For this letter it's also received from the superintendent district court today, indicating that after the verification of the official record, nothing could be traced out.
Peculiar that no such person is there.
Connected with the case number 91, corresponding to investigation. This would have been judgment issued from so I think questions put whether this is taken the fund with yes. This letter you have already given, 21st November. Now this is what it is with reference to who is appearing?
Dean, senior advocate, Dean.
DP program. You give this report. Ashok Kumar, no? The IIC Rajkanika PS has placed on record a report dated 13/2/2026, indicating that despite the best efforts, the whereabouts of the appellant, Ashok Kumar Das alias Babuli, could not be ascertained. we could not be ascertained. The report is already placed on the the matter, the appeal is ready for hearing. However, none appears for the appellant. In the interest of justice, adjourn to next week, including the next weekly weeks. Yes.
My lord, that matter.
Next weekly list it will be included. Yes.
For hearing.
Give that report, please.
Just a point.
Just yes.
Just a
The next 3
item. Extension.
extension of
the-
time.
Letter from the consent trial court has come.
Extension of time. Special college of extension of time. 3 months. 3 months तो दिए थे भैया और again letter. Three more months. Extension date or last order the clip. On 30th October 2025, the learned special judge Reliance Baleshwar had sought extension of time for 3 months to conclude the trial in TR case number 17 of 2011, which was allowed. However, it seems that the trial could not be concluded within the extended period of time. Hence, he has requested by letter dated 20/28/2024. The special judge Baleshwar has requested for further 3 months to conclude the trial. Reason being for the reasons stated in the letter, I am inclined to allow the same and extend the time for the period of 3 months. Okay.
Item 4.
May I please, your lordship?
Sir,
In this case, my lord, my lords have granted bail to the petitioner on 4/9/2024, and after getting bail, my lord, they threatened the informant and his daughter, my lord.
4/9.
4/9/2024, bail has been granted. My lord, kindly appendix 2, my lord. Then, my lord, on 24/12/2024.
You are the informant.
Yes, my lord, I am the informant. So on 24/12/2024, the informant filed an FIR before the police station, my lord. And till that, nothing has been happened. In the meantime, my lord, the accused did not appear before the trial court, and warrant has been issued, and they waited for 1 year. And previous month, my lord, he has granted bail, and the evidence has been passed, and he has been.
What happened to the FIR which you have lodged? What happened to this FIR?
My FIR, nothing has been done, my lord. 1 year has been.
Annexure 1 is the FIR.
Yes, Annexure 1 is the FIR.
What are the offences?
Offences, my lord, in my case, the offences are 206B of BNS, 232, 351, 356, 66 of the IT Act, and 67 of the IT. In my first case, which my lords have granted bail, it is an offence under 376 clause 2 of the IPC, my lord.
Yes, madam.
My lord, in this case, on the last occasion, your lordship called for instruction, my lord. My lord, as per the allegation, they stated that there is a ID created on the name of somebody, and there is a threat in stating that I am boyfriend, I have to give you threat, discloses everything. They are given a
Photograph
screenshot.
of the daughter of the informant.
Given a screenshot, my lord, for the same.
Instagram and WhatsApp you have been sending.
That there is nothing there, my lord. I also give it
Yes.
cyber.
You have to tell me. If he is indulging after getting bail, we have to cancel it.
That is the
That's
cancellation.
what I asked you.
He's
Condition is
never
violated as-
in anything, my lord. He is a working man.
report
And
has
also
come,
I
it
have
also
given a
has been-
cycle.
So apart from this, the ODPS case number 27/2024.
No, after the bail granted to him, there is an FIR. What happened to that FIR? Have you investigated?
The status we have to take.
That's what he says that on 4/9/2024, bail was granted.
Yeah.
Right. On
For the fair allegation.
4/12/2024, the respondent number 2.
My lord, I also given.
Enlarged on jail by this court. Subsequent thereto, he has it is alleged that subsequent.
Lordship may can claim the report.
No.
Investigation is going on.
That's what I'm writing
Report-
and place it on record with C.
Report from the different quarters are sought for.
Hmm.
The
Subsequent thereto, it is alleged that he had been threatening the informant as well as the family members, even indulging in harassing the daughter of the informant. Therefore, an FIR being the wholly PS case number 36 of 2025 had been registered on 22/2/2025. The state council is to the Learned State Council appearing submits that the investigation of the case PS case 36 of 2025 30 PS case 30 is still going. Let him file a status report regarding the same. Regarding the same.
I don't know.
I also given a my lord.
Appearing for opposite party number
I think
2 or oblique the accused, however refute the allegation and submits that the FIR has been deliberately registered by at the instance of the informant, aiming it to get the bail granted by this court, cancelled.
I also given a document in the cyber, my lord, that in the false name there, I also given an acknowledgement to cyber.
You file a response.
Fine.
Let file a
And
response.
trial also smoothly running, my lord.
File. Yes.
My lord, in this case, I'll take my lord's attention, my lord. After getting the bail, my lord, the accused person did not appear before the trial court. So warrant has been issued. And 1 year he has waited. Thereafter, my lord, he filed a 482 application and bail has been granted by this court, my lord.
Last trial.
1 year again se wait kala. They did copy right.
8 तारीख last examination ହେଇଥିଲା ଦି ଜଣ appear.
See, you bail is granted. You are indulging in all these things. You
My
can
lord.
appear in the trial court.
No,
And CW issued. Why is the bail should be there? I'll cancel it and.
no, my lord. He appeared there. Trial also smoothly on the 8 also last
You file
examination.
response, I'll cancel it otherwise.
No, my lord.
If you don't satisfy me and you don't go to the trial court,
No, my
you
lord.
indulge in,
In the last occasion, he personally appeared to.
no will not do. He's giving something, just check it up and tell me.
Yes, ma'am.
And file a response. Let him file a response. File a response. I'll have to add some condition. He has to go and appear before the police station every 2 days. That a condition I'll impose. If I will not cancel it. I am prima facie thinking that I'll cancel it. If I don't cancel, I'll put some condition. At least some deterrent should be there. You
Fine.
can't, use like this. Yes, will. Okay.
next week.
Fine.
Trial also smoothly running, my lord. ଦି ଜଣ appear କରିଥିଲେ ସେମାନେ ବି mind of-
ବର୍ଷ ଆଜ୍ଞା ବୁଲିଲେ appear କଲେନି warrant ହେଲା ତାପରେ ଆଜ୍ଞା police ବାନ୍ଧି ପାରିଲେନି after 1 year file
So all these things,
Yes, yes,
you
yes.
bring it on record, we'll see what can.
appear there. And
Yes.
next,
Urgent to next week.
Review.
Date of.
Date he'll be. He'll give a date. He'll give a date, we'll see the date. Okay. Yes,
Item number 5.
yes.
The matter is relating to the regular employees of Oil India Limited and their claim of pension.
Hmm.
Your Lordship on 18 and 25 has concluded the hearing.
No,
And-
there are some
My lords,
gaps, I believe.
my lords.
So that's the reason I have listed. Who is appearing for the? You are appearing?
State is not there.
Given an opinion.
Who is?
For Oil Corporation,
Oil India, opposition party number 2 and 3.
You are appearing for that.
On the Vashish Patnaik I'm appearing. Advocate Vashish Patnaik I'm appearing.
There are some gap while dictating.
My lords,
You have given written note of submission.
my lord.
We have also given.
You have also given. Okay. Can you refresh me today or?
My lords, I can. If your lordship wants
Still.
to, I can. Your lordship.
What is the prime issue which is
Yes, your lordship. I will straight come to the point. In the counter affidavit, the case of the Oil India is that while you were regularized, there was a condition imposed that if we regularize you, you will not claim for pension. But prior to that, the fact is that Oil India Corporation was amalgamated with Burma Oil Company and Assam Oil Company. They signed a MOA. In the MOA, it was a condition that existing employees will get the same benefit and there will no deterioration in the service condition.
notwithstanding the fact that you have given undertaking?
Yes, your lordship.
Yes.
So on different accounts, the Oil India Limited has sought for instruction
Which is the latter one? Undertaking is latter one or the?
undertaking is later, but prior to that, we are already in service in the All India Limited. I'll just quickly refresh your lordship towards Annexure 1, page 15.
Yes.
Annexure 1, page 15, your lordship.
Yes.
It's 28 September 1981.
You have hard copy?
And if your lordship at next page, I'm sorry.
Hard copy. Which one you are giving? I gave 5 hard copy. I have marked something, no?
My
Hard copy is there? Yes, I have marked here, yes. You are relying upon the
Annexure 1, page 15.
Annexure 1, huh?
My lord.
Annexure 1.
It is the MOA.
Page.
Page 15, your lordship. The date of signing the MOA is 28th of September 1981.
28
September 1981.
1981. Okay.
At the next page, Chapter 1, the definition clause 2A states the appointed day means such date as the central government may by notification appoint. That is 28th of 1981.
Definition.
My lord. 2A.
2A. 2A.
My lord.
Okay. Yes.
Now, at page 21, chapter 5, this deals with the right of the employees.
Page 21, chapter 5. Yes. Para P.
11, chapter 5, 11. Transfer of service of existing employees.
Section 11, huh?
My lord.
11.2.
Clause 11.
11.2.
My lords. 11.2 and 3.
Subject to
the rules made in this draft under section 22, every full-time officer or other employee of Oil India who was immediately before the appointed day employed by it in India, and every full-time officer or other employee of Oil India Limited who was immediately before the appointed day temporarily holding any assignment outside India shall on and from that day continue to be an officer or other employee of Oil India on the same terms and conditions and with the same rights, pension, gratuity, and other matters.
Yes.
Yes, Your Lordship.
Yes.
Now, at the next page, page 22, clause 12, it specifies provident superannuation, welfare fund, etc.
12, huh?
Yes.
12.
12, 3.
12.
1 and 3. My lord.
Yes.
Now, I will lead to Your Lordship to my order of appointment.
12, 3, no? This is page
My order of appointment.
2022, no?
22, Your Lordship.
20. Yes. Page 22, where are you reading?
Clause 12, Your Lordship. 12, 1 and 3.
So, yes.
Now, I will lead Your Lordship to the order of appointment of the petitioners.
1 minute.
I'm
sir.
sorry. I'm sorry.
Minute. Page. the successor government company or all
My lord,
the case may be shall soon
maybe
as
after the appointed day constitute in respect of the
20
monies and other assets which are transferred to and vested in it under this section one or more trust having object as similar to the object of the existing trust as in the circumstances may be applicable. So however that the rights and interests of the beneficiaries of this trust referred to section 1 are not in any way prejudiced or diminished.
not in any way prejudice
Or diminished.
or diminished.
My lords.
ठीक है? Yes.
Page 26, Your Lordship.
26.
My order of appointment.
Page 26.
One thing we have to keep in mind, Your Lordship,
एक minute.
appointed day.
Go systematically. Page
My lord.
26. Yes.
My appointment is on 31st of December 1980.
Page 26. What do you want to show?
It's my order of appointment, Your Lordship.
Order of appointment.
Prior to the MOA was signed.
That is 31st December 1980.
Prior to the MOA was signed.
Okay. Appointment. ठीक है. Yes.
Now what they did, after the MOA was signed, prior to that, I was in the appointment, Your Lordship, I already seen. Now what they did as page 31, they issued a fresh appointment order at page 31.
That is January.
Yes, Your Lordship, after the MOA took place.
Press appointment.
My lords.
Page 31, huh?
My lords.
Press appointment letter after the MOU.
My lords.
Appointment letter. Appointment letter. Yes. After. ठीक है. Okay.
Now in page 31, Your Lordship may find.
You shall not be entitled to any pension.
Yes,
benefit from it.
absolutely.
This is where you are agreed by.
I'm grateful.
Okay.
My lords.
Page 32 agreed.
My lords.
At page 32. No pension. No pension. ठीक है.
This is the
This is
only
what is
case. Yes, Your Lordship.
And there was an opinion of the senior counsel P.P. Rao,
My lords.
who has given a clear-cut opinion. They have sought the opinion.
My lords.
And that
Except that
opinion says that
also,
you can't deprive them. That's what the case is. Yes.
except that also, their own managing directors and time and again have opined that the hiring and firing policy, we should not have adopted it because they have got the salary for that point also. So it should be constituted as a regular service.
Yes. What do you say?
So just the section 11 of the Acquisition Act says that only the pensionary benefits shall be to the employees who are regular and permanent.
No, no.
Not-
Otherwise, that the language used is otherwise. Regular, otherwise also. These people are coming under otherwise category.
Right.
You can't deprive. And you sought an opinion from the senior counsel.
But that- Part of the pleading,
It is there.
No, that's right, but it has a persuasive value.
If I
You
may
thought
just
so.
show Your Lordship, the part of the pleading, if what my learned friend tried to show is, Your Lordship may kindly see page number 7, paragraph 7. The petition.
Page 7, your petition?
Yes, Your Lordship. Paragraph 7.
Huh?
That while the petitioners, along with other employees, were in service, they made remarks before the company to include their names in the Oil India Pension Fund through the recognized union, and in the 2004, some names of some of the employees listed in the aforesaid pension fund list, but insofar as the present petitioners are concerned, their names have not been included, for which they made remarks before the management for inclusion of their names, and also requested to give similar benefit, as has been done in the case of 8 similarly placed employees, and basing on such grievance made by the petitioners, as well as other similarly placed employees like the CMD, sought a legal opinion from different senior advocates of the Supreme Court, as well as the Honorable Guwahati High Court, and all through on different occasions, opinion have been submitted by different senior counsel of the company by interpreting the 1981 Acquisition Act. So it was very much they were pleading, and the counter they were not denied it.
They sought opinion and the
Yes,
opinion
Your Lordship.
went against them only.
Though it was, we were not privy to that, so we didn't enclose it. But after the RTI Act, we have made an application, we have filed in memo.
Your Lordship, there's an exactly same case as in the Guwahati High Court in the law. The pensionary benefit was not entitled to the petitioners. In the same.
Show me the judgment. What has happened to that judgment? But challenge in Supreme Court.
Is it already happened as well as it's in-
Check it whether it was challenged or not.
This will be-
Is it
Page
relating
number
to the
42.
interpretation of the same Acquisition Act?
Yes, your lordships. Page number paragraph 42, your lordships.
Para 42. Yes, what does it say?
Is,
Tell me finding.
Thank you.
they are not entitled to the same claim, your lordships. They're paying for the benefits of pension.
Assam Oil Company.
Yes, your lordship.
Release of Section 6. Let us see. Yes. 6(1).
It is not applicable. Master Kandi, para 41. It was the case where the
Which Acquisition Act it talks about?
same, your lordship. I don't dispute it, but lordship, kindly see page 40, the para 41 at page 29. It's not applicable to the case of petitioner.
Yes. Read it.
Which
That's
is
what
why,
I'm reading.
page 41. In
Yeah.
the above case, the petitioners were pensioners who had retired from service of Assam Oil Company on or before 1981. So already retired prior to MOUs took place.
Oh. So you have given appointment subsequently. And these people were continuing. When MOU was entered into, by that time they were continuing and they continued subsequently.
That is
After MOU, you give a fresh appointment letter.
That is a-
There you put that condition. So this is a case where people were retired by the time the MOU was.
Signed the undertaking also that no pensionary benefits.
That is a different story.
I've given a judgment, your lordship, on that
If
aspect.
they're entitled under the rules, you obtain a undertaking makes no difference. MOU date is, what is that date? MOU date?
The appointed date is, your lordship,
MOU date.
28th of September 1981.
28
September 1981.
September 1981.
My lords.
This is what is the date MOU.
My lords.
And here these people were retired prior to 13 October 28, 1981.
My lords.
So this will not help you, sir. This will not help you. Chalo, I got it now. I got it. Yes.
I'm much obliged.
In this case, I am appearing for the Union of India, my lord, with petty number 1.
They have
Oh.
to.
And then you are appearance. Yes.
Item number 6. Item 6. In terms of order of last petition, though I have received some documents for the CD, but I need some more information and documents, should I pray? for
Okay.
it?
Which order was the reason for the application?
So this the up-to-date CD was.
Huh? The order dated 11/9/2025 has not been complied by the State Council and he seeks 1 week time. This is the matter after 2 weeks. Please let him comply. Yes, next.
Item number 7.
Please, your lordship.
Mr. Ponda, one matter of yours, item 16, I think.
Actually, I am in a bit of a soup today.
So I'll
Most of
put
my
it,
associates are either ill or are attending. to-
shall I, we'll do it on Thursday?
We'll
Thursday, because you have argued, but there are some gap, I just
do it.
give me just overall idea, then I'll do it.
We'll do it on Thursday.
Okay, 16 Thursday, okay. Take
Please, your lordship.
9 or
9 also, okay. 16 and 9 Thursday, you are released today. Yes. Yes, madam.
Yes, Your Lordship, this is conviction for 3 years, Your Lordship, NDPS section
You felt that,
20B1. I don't know the whereabouts of this has come for the first time.
whereabouts?
Yes.
What is the age of this?
Maybe 57 one, 67 one. One is the driver and other is the cleaner, Your Lordship. Similar judgment, Your Lordship, was given in another judgment, which has come with a judgment, Your Lordship.
Judgment.
Criminal Appeal 122 of 94.
Judgment.
That are disposed upon 18/11.
35. You are 35 in 94.
Yeah.
And one is 25. They may be there.
Yes, don't know.
And another CRA 122/94.
94.
CRA number 122/94. That was disposed of my lordship on 18/11/25.
It has come along. It has come along with this
Co-accused.
application.
No. Oh, sorry. This
Judge.
appeal, in this appeal, there are
Two accused, Your Lordship.
two
The
accused,
present
that,
accused.
Satyanarayana and Venkataramana. Okay. And what about the other appeal?
That's CRA number 122/94.
Who was there?
122/94. That is the Srimati M. Appala Nara.
What happened? That matter?
That was the dispose of my lordship on
Right, dispose of.
18/11/25.
It has come along with this.
That's right. What have I said?
That is again convicted under the same section, Your Lordship.
Appeal is allowed. And
Yes,
the
Your
imperial
That
orders.
is the matter against the confiscation of that
Vehicle.
vehicle,
I don't think.
that truck. It is CRA number 122/94.
No, that is a different story.
That is the difference.
Different
That is the
story.
confiscation
No,
of that
that's a
truck.
different story. This is
Here is the case is the challenging the conviction order of the
Narasimha. This is appeal number 90.
This is a.
122 disposed of, no problem.
Yeah.
90.
Yes, Your Lordship. My lord, I'll take the LCR and let it come next Tuesday.
Huh?
I'll take the LCR.
You take the answer, argue 94 matter.
Yes, Your Lordship. On Thursday or on Tuesday, my lord may keep it.
It will remain Thursday only.
Yes, Your Lordship.
Thursday. You take it today
Yes,
itself.
Your Lordship.
Take it and almost everything is there, it seems. NDPS, huh?
NDPS.
NDPS.
period
Period undergone, देखो. What is the sentence?
3 years.
3 years.
3 years. Just see the period undergone. Take it up.
कितना वर्ष है तो दो छः 93 production. It is this one's the arrest. Remanded in custody. पूरा कस्टडी से लगने with the expressions of produced. Produced for लिखिए produced ना all in custody. Figure भी चोरने वाला था. Response देने वाला. Figure भी चोरने वाला. Judgment है. Custody. तापर वाला release order के भेज. High Court के भेज. तुम तो बाहर कर दे रहे High Court of Orissa. Return the driving license. Highly testable. We have figured examining the permission and filing the case for the written document. Declare inventory at a declared quality. Order of conviction. Release के पहला release के पहला अपील में बेटा देखिए 24/2/94 11/2/94 Response time वाले September ये series दिन response September
99 PVC पाँच एक करोड़ 94 2 years 92 High Court order नहीं अपील नीचे 94 रे की सीट नहीं
क्रिमिनल रिवीजन नंबर 593
Very difficult. You have a very difficult case. Very meticulously conducted prosecution.
I'll take the LCR, your lordship.
See, the magistrate was there, magistrate also deposed, and independent witness was in favor of the prosecution. There is a chemical examination report. How will you get out of 50 compliant, 50 compliant?
5 quintals, your lordship.
Very difficult case. Now only concentrate on period undergone. the C period, what is the period? Have you got it?
Say, no muscle, 3593 arrested, 11 to 94, that is the judgment was pronounced and on that. But when the region bail, that part has not come.
This court, na? This court granted him bail.
11/2/94
Judgment is
11/2/94.
11/2/94. Yes.
No, no, sir, yeah, this is very good.
Filed by the prisoner from jail. 97 jail.
Period undergone नहीं गलत. 17/3. 97. That means period under. We'll only check your lord. We'll only verify your lordship whether the period is undergone or not.
Huh?
We'll only verify whether the period is undergone or not, your lordship. Because on
Well, Lordship, you must have served the sentence. So, Lordship, may kindly see the order dated 17/3/1997.
17/3?
1997. Peruse the petition sent by the petitioner from jail.
17/3?
1997.
What is the petition? Petitioner from jail, huh?
Jail.
Petitioner declared for an order directing the inspector to return the driving license, wrist watches, money purse, and the copy of the prosecution report appears that except the driving license, nothing else as stated in the petition seized during the investigation.
so 11/2/94 the judgment is, and this is 17/3/97. So almost 3 years.
When the bail was granted then?
It was not released.
Huh?
That is a 3 years punishment.
Not released on bail.
93 years arrested. And 11/2/94 the judgment was passed. And 17/3/97 is on the custody as per the order. That means 90.
Don't know whether in custody in this case or another case, who knows? Nothing is there. Let us see the Wakalatnama. Wakalatnama is filed from jail or what? Just see, check it up.
Yes, Bakalatnama.
Yes, from jail.
No, it is jail stamp ଅଛି 22/94 ରେ stamp ମରା
नहीं, सब assistant jail कोरापुट.
22/94 ରେ से
Jail to assist. Wakalatnama is from jail. So he was in custody.
88.
Wakalatnama, if you see, that is on 20th February 1994, Raigada. Sub assistant jailer, sub jail Raigada.
26/9/94.
These people might have undergone already.
Undergone.
Appellants open, appellant broken now. I am to return with 2 sets of SR in the jail criminal appeal number 98/1990
Undergone.
on the prisoner appellants. Hearing notice jail.
Really undergone, at least.
undergone.
They might have been released from the jail.
97 ସେ ପଳେଇଛନ୍ତି ସେ ଜେଲରେ ଥାଇକିରି ପକେଇଛି ତା ରିଲିଜ କରିବା ପାଇଁ
ତାକୁ ରିଲିଜ କରିଛି ତାପରେ।
ତାପରେ
सतरतीन खाली से ड्राइविंग लाइसेंस तो क्लेम करता बहुत किसी बट so far the affidavit filed by the IIC that driving license था लेके दी एक वर्ष सिंपल केस होगा हम तो ने इधर जेल पार्टी की जाई थी उसको वो भी ऐसे नहीं लेके गए
See, 17,196 order, if you see, it says peruse the prisoner's petition. Then standing counsel shall take the instruction in the matter. Appears to prepare a copy of the said petition and supply the same to the standing counsel.
Prisoner petition also there.
Standing counsel submits that he has not been able to obtain instruction due to paucity of time. So and so. Despite the order dated 17,196 and 1/2/1996, then standing counsel could not obtain instructions and a copy of the petition to the inspector asking him to so by so and so, why shall not be directed written back. The article sees from the copy of the affidavit also. So copy of the affidavit is in question stated to have already been served. 60 on so and so of his so and so.
And page 60, that prisoner petition is there, dated 20/12/95. That's what the receipt
60
on 11/1/96. Prisoner petition.
Flag a prisoner's petition of appellant number 1. All prisoner petition, everything is there. Already undergone, madam.
95 ର ପ୍ରିଜନ ପିଟିସନ କରୁଛି କଷ୍ଟଡି ଭିତରେ ଅଛି ଏବଂ
35
73/97 order so that he is in custody.
The impugn judgment is
is
dated
11/2/94.
94. Already undergone. Sufficient period. They might have been released thereafter.
Automatically can. The 73/97 is driving license to release kara.
If you see the affidavit dated 27/3/1996 filed by the sub-inspector of excise, Bhubaneswar, he says that the appellant who is a prisoner in Koraput jail submitted a representation to the registrar judicial of the praying for return of the seized article, such as the driving license, one automatic so and so. The Honorable Court passed this. That means on that day he was in custody when the affidavit was filed. Humbly submitted that on the deponent along with the other excise officers, staff, Raigada had performed the patrol both the driver and just see para 14 and 15 of the affidavit. Do you have the affidavit? It says para 14 says that the case ended in the conviction on 11/2/1994 on the basis of the prosecution report dated so and so. Para 15 says the accused persons are now serving the sentence awarded to them by the Court of Session at Koraput Jail. This is filed on 96, 27/3/1996. Conviction is 1994. They served out the entire sentence. Served out the entire sentence, madam. Okay. Evidence is done. PW. इतना PW है, print out निकाल के. Okay. Judgment reserved. Okay. Next.
Item number 8.
Appearance list है. कौन appearance दोनों लिख के उसमें स्टेली ना मेरा भी होंगे. Yes.
Item 8, he has mentioned, will be taken out Thursday. Someone mentioned will be taken out Thursday.
8. No, that is 9. Mr. Panda said. Mr. Panda said 9 will be taken. This one.
The first hour, one lady mentioned item number 8.
Anybody is mentioned?
Yes. She was mentioning to take it over after 2 weeks.
Okay.
But
Acha, okay. That lady mentioned.
Thursday.
Yes.
Item number 10.
10.
There were 2 appeals in item number 10.
Yes.
I will be appealing the first appeal in CRL 307 of 1995. The other appeal, nobody is appealing since long. The other appeal, I'm not there. I'm not the advocate in the other appeal. They arise out of one trial. They preferred separate appeals.
Okay, you argue, see that both of them will ask.
Yes, my lord, can it be taken on Thursday?
Start. You such a senior counsel, what you can. I have not also read. You also start. Let us see.
Yes.
Let us read both of them. Connected file, sir. Connected file at the audio. You start reading. Let us read. Let us understand. It will be spilled over to Thursday.
Yes.
Let us get the idea. What is the case is? Huh? I don't expect you like people should ask for adjournment. You should get ready. Youngsters can do that.
My lord, 940 pages.
No, it's all right. No problem.
May I start with the judgment, my lord?
No, we should not be big judgment. Small judgment.
Well, the paper book is a big one.
Huh?
Paper LCR is quite 940 pages.
Oh, all are not relevant. Let us see.
May I start with the
What are the offenses?
The offense is 457, 395 IPC.
This appeal, there are 2 appellants.
Madam.
And the other appeal?
One appellant.
One appellant, huh?
The place of judgment, sentence and conviction.
It's 1.
Yes. Let us see. Yes.
Sentenced.
Accused is in custody in this time.
Sujit.
This is
Sujit.
yes. Sujit Kumar Khuntia, age 32. Accused at that time was in custody.
Yes, he was custody for bail.
7
years conviction, na?
7 years.
3 years, 7 years and then 3 years.
May I play the sentence? Page 20 of the judgment.
And to arrive for 7 years for 395.
Yes.
Yes.
And arrive for 3 years for 27.
Yes.
Answer.
Exact.
He is the only one who is convicted for answer.
Okay. The substantive sentence is 7 years, 395.
Yes.
Okay. See.
Let's start with the judgment. Madam.
Yes.
The above accused persons, here there were 6 accused persons. And it was tried with the court of learned assistant sessions at Atgad.
3 of them are convicted.
Yes, 3 of them convicted. Other have been released. I could tell you. The above accused persons are charged under section 457 by 394 IPC for having committed the offence of working house trespass by night and committing dacoity. Accused Chogala alias Dhirendra Kumar Behra, Tukuna alias Sujit Kumar Khuntia are further charged under section 27 of Arms Act.
Yes.
The accusation lead to the present trial of the accused person above named. In brief are that on 19/9/92, after taking their dinner, the informant Vidyadhar Pradhan, his parents, wife and children slept in their house. In the midnight, the mother of the informant.
No, let us see. How many accused are convicted now?
3
3.
out of 6.
Under section 395.
395.
And
27.
2 of them are acquitted.
Yes, madam.
Who
3 of them are
acquitted?
there.
On the background of foregoing,
And
para 12 test foregoing discussion, conclusion that the prosecution has well established its case against Khaira, Dhirendra and Sujit.
Madam.
Khaira, Dhirendra filed this appeal. Sujit, you have
is
failed.
this.
395 penal code, and against Sujit 27
Yes.
addition
Yes,
27.
one second.
But read section 391. 391. When 5 or more persons conjointly commit or attempt to commit a robbery, where the whole number of persons conjointly committing or attempting to commit a robbery and a person present and aiding such commission or attempt amount to 5 or more, and every person so committed, attempting or aiding, is said to commit the crime. And come to 395, you have been convicted at 395.
Right.
Just see 395. Whoever commit docaity shall be punishable with an imprisonment of life or with a rigorous imprisonment for a term which may extend to 10 years. It's also fine. Now, 6 persons were put to trial. 395 satisfied. But convicted 3. How will you sustain 395? Less than 5 ಹೇಗಿಲ್ಲ na? Can you convict under 395 less than 5%? Because you are acquitting. The 3 people are taken out. They are acquitted. They have not participated. Then how will you bring 395? It could be a case of 394.
Yes.
Robbery.
House
392, read 392. Whoever commits robbery shall be punished with rigorous imprisonment, a term which may extend to
10 years.
10 years. Shall also be liable to fine and so on so.
The definition of robbery 390.
Hmm.
In all robbery, there is either theft or extortion.
This could be a case of robbery, not 395. Let us see. Now, this is the prima facie view. Let us see. Now, come to the acquisition. Come to the acquisition. Okay. Para 2, just read. Para 2 of the judgment. Read it. Madam, eyewitness, just concentrate on eyewitness. We have seen it.
The accusation leads to the present trial of the accused person above named. In brief are that on 19/9/92, After taking their dinner, the informant Vidyadhar Pradhan, his parents, wife and children slept in their house. In the midnight,
Vidyadhar Pradhan,
his wife,
just see
parents,
Vidyadhar Pradhan is PW. Just take it up. Simultaneously, take it up. Last page is Thibo.
PW1 Vidyadhar Pradhan.
PW1, PW
One.
1, okay. PW1.
His
Next,
parents,
parents. Take it up, which parents and wife and children, whether they are examined or not. Okay, next, proceed. Slept
Yes,
in
sir.
their house, she will find it out.
Yes.
In the midnight, the mother of the informant woke up
to attend the call of nature, and when she opened the back of door of the culprits forcibly entered into the house and threatened the parents and godmother of the informant on the point of knife, and subsequently one of the culprits assaulted and threatened the informant and his wife, and other culprits entered in the room and removed the articles by breaking the box and trunks. They also threatened the informant and his wife by pointing knife and asked for the valuable including Hanuman coin. The culprits had removed 2 gold rings, 1 gold necklace, 1 broken tikka. Am I right?
Okay. Rupees so. Okay, chalo.
Before leaving the house, the
Subsequently,
culprits
next page. Subsequently, the informant managed to come out
changed
from the room
through an internal passage and informed the villagers. His brother Sunakar,
Sunakar examine, just check it up. Post huh? Okay. Just check it up who all are the witnesses. Examine who has witnessed the incident and post occurrence also. Okay. Sunakar, and who has witnessed a video show regarding the occurrence.
Subsequently informed the fact to the police. In the same night, Did and OIC had arrived at the spot and drew a plain paper FIR, Exhibit 1, and took up the investigation. The police staff, along with some of the villagers, searched for the accused persons and subsequently chased the accused person near Chaga railway station and caught hold of accused Khirosau.
Caught hold of accused
Khirosau. Recovered one bag containing some garments, gold and silver ornaments, and other articles. And
just check it up TI period, whether TI period has taken place. Conducted
magistrate
TI period of the accused persons as TI period of the articles.
That has been conducted.
Okay. Yes. Silver ornament and so and so.
IOS also seized 4 cycles led by the culprits near Bhutudi Chakko and railway cabin of Chaga railway station under exhibit 2. During the spot visit of the scientific officer, 1 pencil touch, suitcase, box.
Subsequently, while under arrest, the accused Dhirendra, that is another accused, gave recovery of the bag containing the gun,
pointed iron rod, knife, and cartridges, 1 handkerchief containing copper coins. Exhibit 5.
Specimen fingerprints
are also collected and examined. The statement of witness Narendra Behra were recorded by the then came announced.
Statement of witnesses Narendra Behra,
Narendra Jadumani Maharana, Daitari Sau
were recorded. PW Narendra
Irendra Behra is PW6.
PW6 and Jadumani
And Daita Sahu is PW7.
PW7, yes.
Jadumani is PW9.
PW9 Jadumani. And Daitari
7.
PW7
were recorded by the then magistrate.
Okay.
Recorded by the then magistrate, second class Arthur 164. Some of the seized articles and accused Jitendra Sujit and Kira were identified during the TI period. On completion of investigation, charge sheet under the afforded section was submitted against the accused persons. The plea of the defense is denial. Simply so, during the examination of the 313 therapies, the accused Kira, Dhira and Sudhit had contended that before TI period, the witnesses had identified them in the police station. In order to further its case, the prosecution examined 16 witnesses. Period 1 is the informant, period 2 and 3 are witnesses to the apprehension of the accused. Hirosau and seizure of articles under exhibit 2 and 3. PW5 is the cabin man in Guru Jhatia railway station during the time of recovery and seizure of the articles and absence of the accused Hirosawa near the railway station cabin. People 4 and 11 are the witness to the seizure of the attendance register of Odisha cotton mills. He was employed, one of them was employed in cotton mills. Relating to accused Ajay Kumar Swine. He has been acquitted. Pidul 7 is this Daitari Sahu, to whom accused Ajay had requested to spare his cycle. Pidul 6 is the brother of the accused Dhirendra, whose cycle was utilized by accused Dhirendra during the commission of the alleged crime. Pidul 9 is Jadumani Maharana, whose license token was fitted in the cycle of PW6. License token. PW 8 is a witness to the seizure of the article seized during the visit of the scientific officer. Exhibit 5. PW 10 is a witness to the recovery and seizure of the articles according to the person of the accused Sujit Kumar, Kuntia and Dhirendra, where Exhibit 6. PW 11 is Bhagyadhar Sahu, in whose house accused Ajay Kumar Swai was residing as a tenant during the occurrence period. PW 13 was the OIC of Gudi Jhatia PS. PW 14 and 16 are the ASI attached to the Gudi Jhatia PS, and PW 15 is the magistrate of second class, Patgod, who had conducted TA parade in respect of the suspects and properties. 16 nothing, no?
16.
16 थोड़ी
16.
Bamdev Naik.
Bamdev Naik.
In order to bring home the charges under section 457 by 395 IPC and under section 27 of the Arms Act, the prosecution has to establish the following ingredients. 1. Whether in the occurrence night the accused person had committed lurking house trespass by night in order to commit dacoity in the house of the informant. Number 2. Whether in the occurrence night the accused person being more than 5 in number committed robbery conjointly in the house of the informant. Whether in the occurrence night accused Sujit and Dharmendra were illegally possessing prohibited ammunition, that is gun, bomb and explosive materials. So far as offense under section 457 by 395 IPC are concerned, the prosecution mainly relies on the materials relating to apprehension of accused Hirosawa and recovery and seize of some of the stolen articles from his custody, as well as seizure of a cycle of the culprits and the identification of accused Khiro, Sujit Khuntia and Dhirendra Behera and other circumstantial evidence such as absence of accused Ajay Kumar Swai in Odisha cotton mill and in his rented house during the occurrence night, and availability of fingerprints of accused Khiro, Dhirendra and Sujit in the seized articles recovered from the house of the informant and the statement of the accused Dhirendra and Sujit leading to recovery and seizure of a bag which was concealed by them containing one country-made gun, cartridges, knife and other articles. The genesis of the prosecution case has been assailed on the ground that the prosecution has not proved the FIR properly, and the FIR which has been marked as Exhibit 1 is not genuine and tenable in the eye of law, being hit under section 162 of CRPC. In this regard, the learned defense advocate has relied on two decisions reported in 1994 1 OLR, page 182, Pradeep Giri versus State, and 1988 Criminal Law Journal, page 1835, Dulal Chandra Ghosh versus State. It is in the evidence of Pidul 1 that soon after the occurrence, he had intimated the police over telephone regarding the occurrence, and within 2 hours, the police arrived at the spot. According to PW 13, after recovering the telephonic message regarding the dacoity, the ASI had made stationary entry number 233 dated 13/9/92, and thereafter he along with other staff proceeded to the spot, and he reduced the oral statement of the informant in writing, and as it revealed a cognizable case, he treated the same as FIR and took off investigation and sent the FIR to the police station for registration of a case. Investigation. On perusal of the FIR, it appears that it had made his endorsement on the body of the FIR at 3:30 AM on 19/2/93 under Exhibit 1/1. and the SI has registered the PS case 80/92 at 8 a.m. 3:30 8 a.m. On 19 to 92, under Exhibit 1/3, PW 16 has corroborated the fact. In the case of Ramesh Bhav Jadeja versus State of Gujarat, reported 1994 7 OCR, page 610, the Honorable Supreme Court held as follows. From time to time, controversy
See,
has
the
been
defense
raised.
has argued on 2 points.
Well,
One is the FIR. Take FIR is not properly proved. That the trial court has discarded upon the judgment,
Well,
saying that trade distinguishable case. Second is TI period. In
Well,
so far as the TI period of Khaira is concerned, it is doubtful because he was exposed twice before.
well,
And in so far as Sujit and Dharmendra is concerned, the TI period was believed by the trial court,
Well,
saying that, see, they were in the jail custody only, it has been done. And recovery is proved by PW 13 and PW 15.
well,
Recovery is proved. In the looking into the evidence and slight contradictions are maybe there here and there. How will you get out of it?
well, the very first part, my lord had picked up the very first instant, that is the
So
number of persons.
you just see what is the period undergone. We can reduce the sentence.
My lord.
Converting it to robbery instead of dokaiti, we
My
can
lord.
reduce the sentence.
My lord, well, I'd certainly like to argue on this, the number of persons, where it can be and where it cannot be. We can be convicted or we cannot be not be convicted in case of robbery, dockets. 500 more person that part.
That's there, but it can be a case of robbery.
It can be case of robbery, they have left interest person.
But specific because this is a lower offense. So therefore, specific charge is also not required to be taken. So we can convert it to robbery. If the period undergone substantial period is there, then we can think of doing it. And robbery says fine also.
Well,
robbery says fine also. So we will have to impose fine also. Yes. Yes, Mr. Panirai was saying something.
Can be sustained under section 395 or not? That can be sustained subject to the condition that there must be a finding by the trial court that there were 5 persons.
There is no finding. I've seen it. That I was very carefully looking at that thing. Rather in the contrary, Nursing, Ajay and all are clearly acquitted and saying that they have not participated at all. They were not there. They are not participated. If they have not participated, the strength reduced down to less than 5. If less than 5, 395 goes. But how will you get out of robbery? It is a lesser offense. And robbery, fine is also there. And fine. Not or fine. In the robbery, what I see. And fine. So fine is that fine 300 rupees fine is already imposed. We can increase the fine and just see the period by sustaining the conviction and the robbery provision.
Dhiraj man had undergone 1 year, 1 month, 23 days. And Hira has undergone 1 year, 2 months, 19 days.
Sujit, you find out, huh? Sujit, you have to find out. So that is how we are thinking the overall. Evidence has to be gone into. If you can just go through the evidence, you got it. Just see the evidence. Just
I was also, but my lord friend has already picked up that point that if.
That I have seen. The trial court has given a finding to that extent. Benefit of doubt would have been given.
Then
if there is a finding that the 5 persons were there, then what Mr. Padingray says is correct. But here the findings are different.
Yes,
specifically it says, I'll show you. Specifically,
yes,
Yes, more or less.
my friend is more concerned that
Again,
her client is the convicted under 27th answer.
second 3 years. is-
see, 27, 3 years makes no difference because substantive sentence is this. Reduce the sentence, you can reduce the sentence for the entire.
E-finding star. Para 10. per attendant. There is absolutely no material as to conclude Ajay as one of the culprit. Per attendant,
Yes, per attendant says Ajay was there. Why was not there? Basically.
there is also no other material against other accused person per attendant. Yes, 17 judgment. Right?
No, he is not justifying why 395.
Yes, ma'am.
Not even a single sentence anywhere.
Um, 17/10/92. Yeah, Dhira. 92. Dhira ହଉଛି 1992. କ୍ଷୀର ହଉଛି 1992. କ୍ଷୀର ସୁଜିତ ବୋଧେ ଧୀର ଆଉ ସୁଜିତ ଏକା ସାଙ୍ଗେ ବୋଧେ ରହିଥିଲେ। ଆଉ ରିଲିଜ ହଉଛି 10/93 ଧୀର। ଆର ହଉଛି 8/93। ଜଣେ କିଏ ଗୋଟେ ଇଣ୍ଟରିମ୍ ଯାଇଥିଲା ଅଳ୍ପ ସମୟ।
Sujit was in custody.
ଦିଟା appearance? First ମୁଁ 307/95 କଲି।
135/96.
ଗୋଟେ ମିନିଟ।
Seven years they might have been taken into custody. And when the bail was granted.
No, 135.
21/3/96. The petitioner may be released on bail. When is the judgment?
14/11/95. 14/11/1995. 14/11/95.
Again 5 months, about
Okay.
roughly about 5 months. After conviction, about 5 months, huh? Roughly, and just check it up. And just see the evidences also. Just we continue. Huh? If we can conclude, it's all right. Otherwise, but mostly this is what the period undergone, madam. You
Yes.
see period undergone. You have an extra burden that you convicted under 27.
Yes, Your Lordship. Extra 3 years I have been convicted.
But 3 years.
Yes.
But the main offense is 395, 7 years.
Yes, Your Lordship.
So if it has to be reduced, it has to be reduced proportionately. Proportionately. That's not an issue. But just check it up. What are the involvement? Okay. I'll just come.
Good.
In 135, Your Lordship. 135.
Huh?
In 135, Your Lordship. 135. This in my case, Your Lordship. Arrested which is 17/10/92.
Criminal repeat 135, huh?
135.
95. Sujit, huh?
Yeah, yes, Your Lordship.
Arrested on
17/10/92.
17/10/92.
And released on bail 18/7/96.
18/7/96, huh?
Yes, Your Lordship.
Continuously remain.
Continuously that is not there.
Have we checked it? Just see the trial court record. Trial court record, if you see. And I'll see the trial court record. See the bail bond. Charge sheet, just see charge sheet.
Charge sheet.
Charge
Both were accused. The arrest date is there.
Arrest date is
Yes,
there.
man. Accused Dhiro and Suji were arrested on.
And proceeding, just see, trial court proceeding. Order sheet, just see order sheets. Arrested on 17/10/92. Incident?
Incident
Incident is
1992.
92, 19/9/92.
Incident 19?
9/92.
9/92. Let's see.
Dhiro, the appellant in 307, he was arrested on the same day, 1992. That about this accused Dhiro and
Just see the proceeding, whether proceeding committed so and so. See, proceeding, if you see, 14/9/93 proceeding, additional APP is present, accused Dhiro, Dhirendra, Kira, Dhirendra and Sujit and Ajay are now in jail custody. Okay? Accused Dhiro Sahu, Dhirendra, so and so Sujit,
Dhiro was
Ajay are produced in the custody.
8/12/93 Dhiro was released. 8/12/93. 8/12/93.
Dhiro. Where is that proceeding?
Dhiro. 8/12/93.
8/12. This is Dhirendra. Kirona Dhirendra. Kiro. Kiro arrested on
1992.
1992 arrested.
And released on 8/12/93.
8/12/93 released.
And Dhiro is concerned.
Dhiro
17/10/92.
17/10/92 arrested.
Released on
12/93. 10/12/93 release.
Judgment was on 14/3/95. Judgment was on.
No, this is during trial.
This is during trial.
Let us see after conviction what happens.
Judgment was 14/11/95.
Judgment 14/11/95 is the judgment.
And bail was granted 21/3/96.
21/3/96.
4 months 10 days.
96. Bail. Here, Dhiro also same thing.
Yes, both.
14/11/93 judgment. Total calculated 21.
1 year, 1 month, 23.
No, total.
Total 1 year. So far as the Dhiro is concerned. 1 year, 2 months. 1 year for 5 months. Trial period. Total.
No, during trial 1 year.
1 month, 23 days.
October, 93 year. 92. October 92 he was arrested. 17th October. 93 was released on bail.
Yes, ma'am.
So 1 year, 2 months.
1 year, 2 months.
Roughly, 1 year, 2 months. Here after conviction.
4 months, 10 days.
2 months, 1 year, 6 months roughly.
Approximately.
1 year,
6 months.
6 months. 1 year, 6 months. Here, Kiro?
92.
7 months or kya?
1 year. 1 year, 2 months, 19 days. 1 year, 2 months, 19/9/92, 8/12/93.
Totally, I'm asking.
Again, 1 year.
1 year, 7 months roughly. 1 year,
7 months.
7 months. And what about Sujit?
Arrested is 7.
After conviction, same. Sujit also.
Yes.
No. Released on bail is 18/7/96. After judgment,
18/7/96.
So maybe 8 months.
Judgment.
Judgment 14/11/95.
11.
95.
No, trial, during trial, just see.
Arrested it 17/10/92.
But when the bail was granted in before trial court?
Bond has been repeated. 1293. 1293. December. Our net. Barit 19. 15 years. 93. 93. तुम 10 बार 93 क्यों बात कर रहे हो?
एक पर थी।
Good question, good question, good question. Bharat 4 minutes.
पूरे बाहर पड़ी हुई ऊपर ऊपर इंडेक्स ठीक है अच्छा सर सिक्स
Read the proceeding, from the proceeding you'll get it. That is what I told you. This is. Very good feel. See, 22/11/93, Sujit got the bill. Proceeding. Sujit got the bill on.
My lord, we are not getting that.
Hmm?
May I have the case number? My lord, we are not getting that.
Just see the proceeding. I gave you half an hour for that only. You didn't find.
Want the entire order sheet.
Just see 22/11/93 proceeding. Read it. Second paragraph. Memo dated 18/11/1993 with a direction that the petitioner and Sujit Kumar Kuntia may be released on bail, furnishing bail on so and so. He has got to bail on 18/11/93. Arrested on 17/11/92, got bail and 1 month he got then, and 1 year, 5 months. Got it. Chalo. I got it. I don't waste time further. Now come to the eyewitness. Who is that informant? PW. One is the informant.
PW1 is the
Let us see PW1. PW1. See. Yes. Come to PW. We can't read it. Do you have PL1 with you?
My lord, I have the, they have probably typed out the depositions.
Have you typed out?
At that time, they must have typed out the legible copies. I have some of these depositions.
Let us see. Give me type copy if you have. Give. Let us see. Then roughly all of you have undergone 1 year, 5 months, 1 year, 7 months, and 1 year, 6 months.
Yes.
ठीक है. रॉबरी का सेंटेंस बताओ.
ठीक है, देखिए ना कितना अच्छे थे.
Mine will be 1 year, 9 months almost.
Only.
मुझे जाइए से एंट्री में.
Some of the deposition and the active statement.
Yes. PW1. This is PW1, na?
Mother taking it. Examine है ना
Sujit name is Chogala.
Yes.
Who is Chogala?
Dhira.
Dhira is Chogala.
Chogala. Chogala is the Dhira. I know the actual.
I recognize Chogala. The help of lamp. And he recognize Kiro also, he recognize Chogala also. Where is the question if he recognizes? Where is the question of TI period? He says I recognize.
I didn't find the book and I do not know the other actions for something. You were more than 1 year there on 9992, then witness said 82, 92 and 92. Again says the occurrence calculation 1992.
Those things I have read it. Next person. One accused gave a kick to me, so the wife got hold of the leg of the culprit, requested him not to assault me and to take away versus also, and about 6. The culprit. What does he say regarding Sujit holding the arms? He doesn't say anything. Yes, he says here, torch by focus of the torch light, I recognize the face of Sujit. Sujit also recognized. Basanta has been examined. They just tribe of the FIR. Basanta.
No, my lord.
Not examined.
Recover the porridge. Chocolate. Here, there in the base. Corrosion. Amma.
तुम्हारा कुछ नहीं ना निर्भर अच्छी
What the butcher has?
निर्भर अच्छी
Nitrogen.
कुछ नहीं
Two. Post of
post apprehensions 2 and 3 no 2 and 3 are witnesses to the apprehension of accused Kurosawa and Caesar articles
I know accused Kurosawa. Police were chasing culprits.
English and China on cheap I think speed of blue
Again.
speed of
First telephonically informed, thereafter at 5 p.m. the FIR was reached.
Yes, ma'am. Is that send that for registration of FIR? He took up the investigation instantly and sent that FIR for registration.
Sujit during the TI period and I also.
Capping man from the railway station. Capping man during the time of recovery. 6 and 8 witness of the Caesar. Caesar of articles during the visit of the scientific officer. Exhibit 5. 10 is the witness to the recovery and Caesar of articles. Only eyewitness also.
Informative. No correlation with other witnesses. Only eyewitness informant only. The other people of the family has not been examined.
Not examined.
And so far as 27
very meticulously narrated things.
27 arms fact is concerned, that was recovered late from this Sujit during his arrest letter. And whether that was used in the occurrence, that is not proved. Since they arrested him, They found, that is what they said, they found a consummate gun within 427.
PW 15 is the JMFC who conducted
TI period. TI period.
Ten, 10, 10, 3, refugee. देखने से तुम्हें पढ़ी थी number 8 160 पर 13 and 14 13 13 162 exhibit 13 and 14, that is on the date of occurrence, the accused Dhirendra had taken the cycle of the brother.
Mr. Herbert Mohan cycle had been usually
1/64 second.
it is Dhirendra. It was between the 13, 13, 14. 13, 14. It's 13, 14. Second visit.
PW2 is seizure. PW3.
Real 2 and 3 are the witnesses.
Witness to
the
chasing
apprehension of
arrest of Hira.
PW3 also same.
same. PW
4.
PW
Hmm? छोड़ो.
He has
PW5.
not supported the prosecution.
Who is
No,
PW5?
sir. PW5 is the railway station, cabin man of the railway station.
Cabin man of the release.
During the time of recovery.
Arrest. PW5 is the witness to arrest. PW6.
6 and 8 witness to the seizure of the article.
PW6.
8 and 6.
8.
6 and 8.
8. 7 also.
No, 7 is not the 6 and 8.
6 and 8 seizure witness.
Yes.
Seizure of what? Gold ornament.
Seizure of, during the visit of the scientific officer. Recovery of
One box from the house of the villager.
accused.
6 is not supported. 6 is not supported.
Police compelled me to give statement.
PW2 6 not supported.
During exhibit 6.
Supported. PW 7. PW8.
7 is 33.
Cycle.
Accused was to spare his cycle.
It was not supported.
7 is the person who spared his cycle.
Not say the exact number of the articles.
Household articles. PW8 has supported. PW8 seizure of articles.
Also Vidyadhar. Spot.
Huh?
Vidyadhar's house. Spot. Yes, here is the witness to seizure of some utensils such as tatia and one steel soap case, one arthritis, one box from the house of.
Jima given to Vidyadhara, PW1. PW1, Jima given to
Yes, ma'am.
9.
9.
Cycle was taken by his brother and fixing the license.
Token was fitting in the.
1 to 4.
License was taken. Was fitted.
Hostile.
It doesn't remember.
10. 10.
The seizure of this
That being asked.
weapon.
There is the
Disclose that to his brother.
1992
According to the version,
Lost
Sujit
by 93.
Dhiren.
The seizure of weapons from Dhira
And
Sujit.
Sujit.
Well, I'm talking about PW9.
Acha, 9. PW9 is the whose license was taken.
PW9 is
License was taken and fitted to the cycle.
Dhirendra was using my license token of our GP. License token, cycle license like that.
Dhirendra was taken and his brother Dhirendra was taken.
And I fixed it in his
His
cycle.
cycle.
corroborating evidence.
I was examined under 164 please.
Yes, 10
There is the
country-made gun.
Country-made gun. That seizure date is 10/12/93.
From whom?
By the version of
Sujit
Sujit
Kumar.
and Dhirendra.
Accused Sujit
And Dhirendra.
Kumar Kuntia and Dhirendra gave recovery
Yes.
of the article under the police custody. The seizure was prepared so and gave so and so. No, it is, how would you say it is from Sujit? Both.
Yes, both. On 10/12/93 letters when they were arrested. The seized gun and cartridge are not produced. Are not produced.
Not produced. Where is that?
There also I did not pay any initials to any of the seized articles. You cannot see the detail and description of the copper coins.
There were things are not seized in my presence. Articles were not seized in my presence.
Where does it seized gun?
Please,
These are not produced. Very important. Yes. 11.
Timekeeper, Odisha Cotton Mill.
Hmm?
11 is the
Not much.
house accused of resistant tenant.
Oh, not, that is regarding Ajay.
11
Ajay Swine. He is an
PW
acquitted.
Bhagyadhar Sahu, in whose house accused Ajay Kumar Swai is residing as a tenant during the occurrence. Bhagyadhar Sahu. Bhagyadhar Sahu.
It was the
11 and 12 both.
Hmm?
11 and 12. PW 11 and 12.
Not necessary. Because this is regarding Ajay Swine. He has been acquitted.
13 is
Who is the IO?
13.
13.
ASI 14.
Yes. What do you say? In so far as Sujit is concerned, how the conviction under Arms Act is sustainable? Because the PW1, who is the prime witness for you, informant, PW1 informant, he has not said anything regarding use of any arm or anything of that sort by Sujit. And seizure is PW10. He is also saying that it was not even produced for the court. And he takes the name of both Sujit as well as Dharmendra. Dharmendra. Why only Sujit will be convicted? If it is recovered from both, and it was not even produced, and there is no specific specification regarding from whom the gun is recovered, from whom the iron rod is recovered, nothing is specified. Then Arms Act, how would you sustain Arms Act? Difficult to sustain Arms Act. So then your only strength is PW1 and PW2 and 3. Those who are the witnesses, the police were chasing and arresting Kera. Participation of Dhirendra and Sujit, those who are identified by PW1 only. Nothing, no corroboration as such. And TI period is of course there. PW15 TI period.
He says that he knows, he knew them earlier. I know.
He, that's the problem. TI period is neither here nor there in the sense. PW1 has identified all three of them. By name identified. Why TI period? These three has no meaning. And the other two people, those who other three people, the TI period has been conducted, that is not believed. So TI period is neither here nor there. Only TI period, insofar as the articles are concerned, it can be believed in the evidence of PW15. But the other part cannot be believed because they're exposed. And he says when he went, Khera was already arrested. In the police station he was there. He was exposed twice before TI period. So therefore, that part also not of much importance. I think only the robbery part has to. How would you doubt PW1? And other corroborating evidences are also there. Recovery is there.
They not named them in the FIR, though he knew them earlier.
FIR, but telephonically he said everything.
That is why.
Telephonically he said that the trial court has dealt with.
He clearly stated in evidence that knew each one by their name.
Witness, well, let us see the FIR then. Let us see exhibit 1. Let us see exhibit 1.
नमस्ते विद्याधर प्रधान कृष्ण प्रधान जिला पुलिस नागरिक समय घर प्रदान करती मौखिक आज रात समय घरे शोलु बापा घरे शोले शोले मो सान भाई
Come to the relevant part.
रात गोटे 30 मिनिट समय बाड़ी मत जो मारे मो निज भांगीगला से लोकटा मत हठात सरप्राइज भयर द्वार गली मो स्त्री आगे ठिया होता ସେ ପିଠିକୁ ବହୁତ ଠେଙ୍ଗାରେ ପାହାରେ ବାଡ଼େଇଥିଲା ଆଉ ପିଠିରେ କାପ୍ତାଏ ମାରିଲା। ସେ ବାମ ହାତରେ ଛୁରୀରେ ଧରିଥିଲା। ପ୍ରଥମ ଯେଉଁ ଲୋକ ଘରେ ପଶି ମୋତେ ଛୁରୀ ଖାଇ ବାହାରକୁ ଆଣିଲା, ଘରୁ ଯାଉଥାଏ ଓ ବାହାରୁ ଆସିଥାଏ। ମୁଁ ଘର ଭିତରୁ ଚାହିଁବାରୁ ଅଲଗା ଲୋକଟି ମୋ ପିଠିକୁ ଗୋଇଠା ମାରିଲା। ସେଇ ସମୟରେ ଲୋକ ବନ୍ଦି ଘର ଭିତରେ ପଶି ପ୍ରଥମ ଲୋକ ସହ ଟ୍ରଙ୍କ ବାକ୍ସ ଖୋଲା କରି ଜିନିଷପତ୍ର ବାହାରେ ଥିଲେ। ଦୁଇ ତିନି ଜଣ ରହିଥିବା ସବୁ ଜାଣିପାରିଛି। ସେମାନେ ସାନ ଭାଇର ଶୋଇବା ଘର ତାଲା ଭାଙ୍ଗି ଘର ଭିତରକୁ ଗଲାବେଳେ ଆମକୁ କହିଲେ ଠିଆ ହୁଅ। ଆମେ ଠିଆ ହେଲୁ। ସେ 4 ଜଣ ସାନ ଭାଇ ଘରକୁ ପଶି ତାର ଖୋଲି ଜିନିଷପତ୍ର କାଢ଼ିଦେଲେ। ଆମେ ସମସ୍ତଙ୍କୁ ସାନ ଭାଇ ଘର ଭିତରେ ପୁରାଇ ବାହାରକୁ ଝାମ୍ପୁଡ଼ି ଦେଇଦେଲେ। ସାନ ଭାଇ ଘର ପାଖରୁ ନେଲା ବେଳେ ସେଠାରେ ଠିଆ ହୋଇଥିବା ଗୋଟିଏ ଲୋକ ଉଠିଗଲା। ଝାପ୍ସା ଆଲୁଅରେ ସେ ଲୋକଟିକୁ ମୁଁ ଅନୁମାନ କରୁଥିଲି ଆମ ଗାଁର ଚନ୍ଦ୍ରମଣି ମହାରଣା, ପିତା ଗୋବିନ୍ଦ ମହାରଣା। ଆମର ଉପରମିତି କବାଟ ଖୋଲି ମତେ କହିଲେ ଅନୁମାନ କରୁଥିବା କେଉଁଠି
Then Kira Marana, Chandramani. What is his name? What is his? ସାନ ଭାଇ ଘରକୁ ପୁଣି ଖୋଲି ଜିନିଷପତ୍ର ଆମ ସମସ୍ତଙ୍କୁ ସାନ ଭାଇର ଘର ସାନ ଭାଇ ଘର ପାଖକୁ ଯାଇ ଝାପ୍ସା ଆଲୁଅରେ ସେ ଲୋକଟାକୁ ମୁଁ ଅନୁମାନ କରୁଛି ଯେ ସେ ଆମ ଗାଁର ଚନ୍ଦ୍ରମଣି ମହାରଣା।
ଚନ୍ଦ୍ରମଣି ମହାରଣା, ପିତା ଗୋବିନ୍ଦ ମହାରଣା। 15-20 ମିନିଟ୍ ପରେ କବାଟରେ ଖୋଲି ମତେ କହିଲେ ଅନୁମାନ ପଇସା ଅଛି ବାହାର କର। ମୁଁ ଅନୁମାନ ପଇସା ନାହିଁ କହିଲି, ଯେଉଁଠି ଯାହା ଅଛି ନେଇଯା। ତାକୁ ମଧ୍ୟ ଜଣେ କହିଲା ନାହିଁ ହାତରୁ ଦିଅ। ମୋ ପେଟରେ ଛୁରୀ ଲଗାଇ ଦେବାରୁ ମୋ ସ୍ତ୍ରୀ ତାଙ୍କ ଉପର ତଳେ ପଡ଼ି କାନ୍ଦିବାରୁ ଜଣେ କହିଲା ତୋତେ ଛୁରୀ ମାରିଦେବୁ, କେଉଁଠି ଅଛି କହ। ତାପରେ ଘରୁ ବାହାରି ଆସିଲେ ଓ ଆମକୁ ଭିତରେ ରଖି ବାହାରୁ ଝାମ୍ପୁଡ଼ି ଲଗାଇଦେଲେ। କହିଲେ କେହି ପାଟି କରିବ ନାହିଁ। ଆମେ 2 ଜଣ ଖାନତଲାସ କରିକି 10-15 ମିନିଟ୍ ପରେ ସେମାନେ ବନ୍ଦ ନ କରିବାରୁ ମୁଁ କବାଟ ବାଡ଼େଇ ଶୋଇବା ଘରୁ ଗଲି। ବାହାରକୁ ଯାଇ ଦେଖିଲି କେହି ନାହାନ୍ତି। ବାପା ମା ପିଲାମାନେ ଥିବା ଘର ପଡ଼ିଲି। ପଇସା ଘର ଉଠାଇଲି। ତାପରେ ଘର ବାଟେ ଗାଁକୁ ଯାଇ ବୁଲି ଚାଲିଥିବା ସ୍ଥାନ ପାଖରେ ସାନ ଭାଇ ଅନ୍ୟମାନଙ୍କୁ ଡାକି ଆମ ଘର ଡକାୟତ କରିଥିବା ପରିବାର ସେମାନେ ଘରକୁ ଆସିଲେ।
When he identified only Chandramani Maharana.
ତାପରେ ପୋଷ୍ଟ ଅଫିସ ଯାଇ ଥାନାକୁ ଫୋନ କଲି। ମା ମା ଡକାୟତ ମାନେ ଧକ୍କା ମାରି ଘରେ ପଶି
Chandramani Maharana was subjected to trial or not?
Yes, ma'am, they are not subject.
Chandramani was not in the FIR. He doesn't say anything, and that was registered after 1-2 hours. But in the examination, he specifically says that I identified this man, that man, everybody. In FIR, he doesn't say anything.
He only identified Chandramani.
Chandramani is not even tried. Chandramani is not even tried. Come to Ayu. How it is confronted with Ayu. And this witness is not even confronted that part that you have in the FIR you have not said anything else.
What I did is the oral treatment of complaint with the other present. In writing, as it revealed, constitutional offense, I took up investigation. Formal FIR was made at the PS by ASI BD9. During investigation, I examined the informant, which is spot. Prior to seizure of
He says that on my instruction, one Bimbadhara Sahani wrote the FIR. One Bimbadhar Sahani is not examined. Huh?
Not exam.
And Bimbadhar Sahani wrote the FIR, who belongs to Gurdi Jatia exhibit so and so. Is said FIR, my signature is there, exhibit so and so. Explain to me so and so. Bimbadhar Sahani has other name, but do not know. Oh, Bimbadhar Sahani and Basanto might be same.
Vidyadhar.
And in this paragraph, she's cross-examination again, he says that Basanto scribed the FIR.
But he had examined PW1 at paragraph 24. This cross-examination that you put some questions. Paragraph 24, the cross-examination.
24, whose cross-examination?
PW 13 cross-examination. He had examined PW1.
PW 13, okay. Come to PW 13.
Page 11.
130. We'll continue it. Just check it up. To conclude it.
Right.
There are few gaps here and there.
Yes.
It may lead to an acquittal. Just see you now. Because see, PW1 statement is directly, completely different than the FIR. He says he takes two names who ascribed the FIR. And he again says that he has given the information to one Krishna Chandra Naik over telephone. Thereafter, he scribes the FIR through one Bimbadhar Sahani. And in another paragraph, he says that it is written by Basanto. And in the FIR, he takes Chandramani's name, who was not even tried. And in witness box, he completely takes a different, story. He gives a different story. And he says that all the three, Chogala, Sujit, and Khira, he identified. And he narrates everything. So therefore, if PW1 goes, then what do you have? His testimony seems to be little dicey. If that goes, what else remain for you? And nobody is examined. If PW1 you take it out, then what else? Only TI period. TI period is doubtful because he himself says that I've identified them. And once he identified, where is the question of TI period? By name he's saying, I saw this man, this man, this man. And what is the TI period? No meaning of TI period. Only TI period, insofar as the articles are concerned, that is there. PW 15, to that extent, you can, believe. Very difficult. Just check it up. May lead to
That's
Huh? Those are recovered. That is that. To that extent, PW 15 is correct. TI period is perfectly done. We can't doubt because he is JMFC. Why should you doubt? Apart from that, therefore I was thinking of robbery, but if PW1, how will you treat with PW1 evidence? PW1 evidence is very shaky.
There's nothing like this. There is not before the single war.
Nothing is said. It is altogether a different story. So very minute detail.
And the mother and his wife
Nothing. At best it can be. At best it can be. How will you relate them? This recovery 411 charge भी नथिला, but anyway.
Evidence will evidence.
Smaller offense. Lesser offense, therefore it can be. It can be a 311 maximum. The FIR is doubtful. Yes. I think we should conclude that, Mr. Panikar. What do you say? You want to add anything? No. I don't think you want. Thank you very much. Second matter, first matter, 135, na? You are
Yes.
135 C will be MFS3, and another is 90, yeah?
307.
This is 307. ठीक है. You would have print out. You would take much. I'm retaining this. Huh? I'll give it back. You have given only PW1 and 15.
Only those were required for.
Not legible, then you gave it. And PW1 15 is there, and the rest of the thing I'll take out the printout. Yeah. And keep it to me. Okay, thank you.
Item number 11.
Your Lordship, these are appeals arising out of counter cases. The informant has already passed away. There has been a compromise between the parties and
Who has passed away?
the informant.
Informant is passed away. What is the offense? Convicted under which provision? $324.
Your Lordship, the legal representative stays at abroad, so they are yet to come and sign the compromise affidavit. So your Lordship may keep a longer date.
No longer date. First of all, the informant has died. He has received the injury. Who else? How many injured persons are there? You are appearing for? Huh? Which matter? There are two matters, na? You are in first matter.
I'm for Srinath Pradhan.
319. You are in 323. He is in 319. Let us see what are the facts first of all. Three 24 read with section 149 and 9 B of Indian Explosive Act. Conviction and sentence is 1 year 6 months. Informant died and a large of the informant have entered into a settlement. That's what you say. What is the period undergone? Three cases. No, three. No, no, two cases only. 13 also same.
So that the first acting that is in that the criminal offense instrument is not at the based on the period applied.
No, let us see. Let us see.
Same occurrence, place, date and time is also same.
The one. Four, 5, 6, 7. 8 also died. 9 also died.
13 died.
13 died.
18 died. And 21 died, 23 died.
So that Ramakrishna. I don't know, the same incident. How many accused were there?
Your Lordship, there are
45 accused in a
cases.
second day, huh?
These are appeals arising out of counter cases.
Counter cases.
Yes.
26 active persons there.
No. In the first 319, there are how many accused? 24 accused persons, isn't it? This is pertaining to which FIR? Just see. FIR.
In the
Take it up. Whether he says that cross FIRs, what is this? Another item is 13, huh?
There number 328 in the one.
Arising out of the same judgment.
Yes, ma'am. And there is 395. The document, in number 26. And we have one.
Okay, 319 and the 319 of 95 and 328 of 1995 arising out of the same judgment. 323 is another judgment. Here there are 51 accused. All of them are convicted under 148.
One application. There are
First, let us concentrate on 319. 319. Second matter we'll see. What we'll see? They are convicted under Mr. Panigre and both just see. You please just see the second matter, that is 300. 9, not 19. 325. No. 323. You just see 323, yeah? 323. And Mr. Panigre, you just 319 and item 13, 328. Arising out of the same impugn order. Here they are convicted under 34 and 149. 1 year, 6 months. Okay, let us see who is the what do you call the injured. Who is injured? Have we read it?
Your Lordship, I have no further instruction. Kindly.
Forget about instruction, madam. Just try and help. I'll appoint you as an advocate. Finish it up. I'm aiming at one thing that we can, Mr. Panigre, just see undergone period and we will grant them probation. 323 probation will give, finish it. So many accused. You don't have a place in your jail. 54 people, where will you take them? We'll give them probation and finish it up.
Your Lordship, I'm appearing on behalf of Pratik Naik. So can you please give?
Sorry?
I'm appearing on behalf of Counsel Pratik Naik. So.
It's all right. All right. Call Pratik. We'll just see. 24 years back, the incident took place. Will you do this? 2.5 years. Means it is incident for 90.
W 1, 2, 6, 7, and 4.
Injured. PW?
1, 2, 4, 6,
1, 2, 4, 6, and 7 injured. Huh? Injured. And doctor?
PW 10 is I had examined one Abhay Pradhan, son of Uchav Pradhan of Sansaripur at 12:32 p.m. and found the following.
Following
A breach 3 into 2.
as I said, so all injuries are simple in nature. Okay. Then again two injuries. Two injuries.
Simple.
Yes.
In fact, there is one development in this case, which my friend might not have been pointing out to Lordship.
In right, and they want to settle.
No, not that way. There are two cases your Lordship will see.
Yes,
it was a dispute between villagers. Fortunately, conviction is for a minor offense and
one in your case 148.
Exactly. So we'll place the matter on merit, but the only thing that I think the other appeal also, my friend in learned senior Mr. Naik is appearing under Naik, and they have sorted out. So that your Lordship may be
No, I am only aiming at giving probation.
And that is
in both the cases.
Because if they again send back, because they
no,
have
see,
settled.
54 people, 26 people,
And
pre-filed.
I have got complete information, not only from the local lawyer who is a very senior person, but also from the parties, also through the associate, that they have sorted out. So that maybe only, that may not be mentioned, but
Because
that may be.
the incident had taken place in 90s.
Exactly.
And many of them had died.
And not only that, the punishment is sufficient. Whatever they have committed, this case pendency and the continuing litigation itself is sufficient punishment.
Otherwise also they might have undergone some period.
Yes.
Because in one case,
Yes.
302. FIR was registered under 302.
Yes, yes.
They might have been taken into custody.
Yes, absolutely.
Venturing into all these things, I don't think it's at this.
Yes, that is what I will submit. Because if I go into merit, that will be a different thing altogether. But this, your Lordship, can consider.
That's what we just looking at the first two cases where 324 conviction is there.
Yes.
What kind of nature of injuries have you just? All simple injuries so far. This is simply, and I think your junior can ably do it also. Your junior can ably do it.
No, I just came because your Lordship knows at times the absence creates a misunderstanding. Not for any other purpose. I have full trust. In fact, I am lucky that my associates are.
And but you
only they should be little more dedicated. It's an honest confession here. I think the environment is not that kind of professional environment. So they should be little more like we were during our young days, 24/7. So
you used to depend upon a book. They used to depend upon mobile phone. That's the
true. It is, your Lordship. One question that prompted
you
my
used to read the books to find out some proposition. They look at the mobile.
When I was struggling to get into office, despite Sri SP Mishra being my distant relative, it was difficult to make an entry. So after being returned thrice, I got frustrated. I asked my senior, do you think sir 10 from my batch will be successful? Mistakenly, he said yes. So I said, why can't I be amongst those 10, sir? He said, come tomorrow and join. And that's lucky. You are not allowing me. 3 occasions he said, Dekhiba, nahi. In fact, chamber was full. I was sitting on a bench when I joined initially. जो बेंच रे फाइल एटा करोखला ता दु टिके घुंचेई देकी मु बसथिली 1 feet by 2 feet टेबल टे करिकी and luckily a situation come at 12:30 in the night. I'm not asking them that. I'm saying at least come at 9 in the morning, go back at 10:15 like that in the evening.
No, they should do it. Otherwise, see, these are the opportunities. These kind
And I
of
said
matters
the office is completely open. Like in some offices, if a junior files a case, he is thrown out. In my office, complete freedom to the juniors to file their own cases. Not only that, to engage me for free. And they get printed. Everything is done in my office itself. So I think there can't be any more freedom for growing. I say I may not be able to pay you handsomely, but I can make you a lawyer. if you want to be a
That's very important. Paying bill, mentorship is very important.
and files, no restriction, nothing. And if 50 files are taken away also, I have no chance to know. But I don't keep track of anything. I keep my mind completely free, except conducting the cases which they give me chita. Not that I make a chita of it or verify. I just shared because maybe I found your lordship maybe little bit of free. I can take that time.
It's all right. Again, five, Mr. Panirai, just see, again, injuries are simple.
Yes.
And thereafter 6, 3 injuries are simple.
Yes.
Okay, and 7 is also, injuries are simple.
Yes.
8 also, if you see, 2 injuries, no, 5, 4 injuries. Injuries are simple. On the same day, police requisition to examine Madhusudan Patra. Injuries was possible. Nine, he doesn't say anything about nature of injury. 10, injuries are simple. 11, injuries are simple.
Basan Patra also injuries.
Simple.
Devraj
All injuries simple. 324 because they have used and how many of them have died? Give the original price.
That 149 is also very deceptive.
No, we will not go into all these things. Just see 2, 3, 8, 9, 13, 18 died. 21 and 23. And rest of the people, those who are there, just see 4 was 53 years in 95. And 27, 34 and all, 36, 30, 36, 30, 30, 45. 16 was 45. All are youngsters. We'll do like that. We'll give probation. That's best way. Even if you compromise, you end up with like this only. The idea is not to go to jail.
That I just pointed out, not to be mentioned, but this is a fact. The other side counsel is now there also.
What do you say, madam?
That is the situation.
My lord, we have been instructed to keep this urgent because the
Now let me just clarify.
legal has-
She was saying you will file an affidavit regarding compromise. Nuclear appeal mein, that not done in appeal. So it is just a statement which as an officer of
That will be for the purpose of PO. That will be a persuasive.
Yes. And this as an officer of court, we are giving a responsible statement, not that, not a correct statement, not that way.
An incident had taken place in 90s.
Yes.
And conviction is for minor offences. So this is a fit case where probation of offenders act can be extended.
Should not go inside.
That's all. In the other case also, other case only 148.
Yes.
In the corrected case, only 148 conviction.
It's my case.
And 52 people.
Yes.
All the 3 cases, probation.
And Sabutu, important katha, now the case is over. It is also for free. The senior counsel. Completely. And
You had no disqualification.
And 0 completely. That is. But it is my urge to appear with your lordship. I have got a chance nowadays. I am not waiting because they are only in division. So I rushed in when I heard that the case is going on.
No. Now after they get the relief of being released and PO, you can pursue whatever is.
Not that way. I said because it has never bothered me in my life.
Item 23, sorry, 13 now. Yes.
And that part has never bothered me in my life because I don't have much expectation in that realistic way. So it has never bothered.
So both the things, all the three appeals.
So grateful, Your Lordship.
Anything? So at the same time, he is one of the accused. And here the conviction is 148 only. So same PO. Because it's a cross FIR. It's a cross FIR.
In fact, the case is lucky to be in Your Lordship's board. Very stop.
Otherwise, it will go on and on for another 20
One
years.
order Your Lordship reserved and then released. It was very painful. Because of quantum assignment.
Children Morrison.
I'm a say enough punishment.
And see, we are following the reformatory jurisprudence in India. And incident happened in 1990, and the people in the village are staying now peacefully.
As a lawyer,
and ready to settle also.
As a lawyer, I was born in 91, not even in 90.
Just see, you're not even born in the cadre.
Yes.
So this is the situation. Sending them to jail is adversarial. This is not the idea of our jurisprudence.
And Your Lordships have been always brought in all cases, I think. Those days when 30, 40 judgments were coming. During Your Lordship.
Maximum I try to strike a balance.
That has been Your Lordship's approach always.
Otherwise it will never be ending. Never ending process.
Grateful man.
Okay, thank you very much.
Great.
Thank you very much. Appearance, sir, Sarika appearance. Give appearance. And you both give your appearance in the. And I am appointing them as a amicus curiae. I am appointing him as a amicus curiae to assist you. These people should get something. Both of them will be amicus curiae. First, first matter
Sir, 319.
No, 319 रे ताकू जो कर दियो. 319 रे जो करो. नहीं कोड़ा थले तो एक कोटे मिनट. 319 रे ताकू कर दियो ताकू आको जो को कर दियो 320. नहीं जाओ. ताकू करियो 323. 323 करो. ठीक है? हाँ.
And in fact,
amicus curiae assisted.
By the time I reached Your Lordship and Madam, so he had done it. I just made my presence.
Okay. Thank you very much. What did you follow? What happened? What did you follow? What is probation? Rehabilitation means I'll have to take them to my house to make them stay. That is rehabilitation.
Probation is governed by which statute?
Which statute, and go and read section 4, 5 and 3 of Probation of Offenders Act. Okay. Read it and then you will understand what happened.
That is followed always for reformative measure.
Reformative. You read it. Yes.
In fact, senior Mr. Naik did not come, so they have to take the credit.
But these people are taking pain. Yes. I think we'll stop here. 6 appeals today. Huh? That will do. Yes, Mr. Mishra, do you have any matters?
498 306 conviction. 157.
No, 306 prosecution failed.
Only 498 conviction.
He made a prayer to release him under probation, that was rejected.
50?
57.
498 a conviction.
306 acquitted for 1 year.
Arrive for 1 year.
Yes, my lord.
If fine provision also.
Almost all witnesses have been hostile, my lord, basing upon the statement. Yes.
Are you able to for PO?
PO, my lord, since I think
You have asked for PO there in trial court, which has been rejected.
ଚାକିରି କରୁଛି ସର୍ଭିସ ଥିଲା ବୋଧେ ଇଏରେ ଅଛି କଣ କହିଲେ
Think over Thursday. If PO, it's all right. If you are aiming at acquittal, then we have
yes
to.
my lord since he was a government servant my lord as per the evidence shows that
That what he says is giving a clue to you. Try to understand and read and tell me.
yes ma'am on
Okay.
first day
Mm,